Hey everyone, this week our topic is going to be over antitrust law and labor law, and those lessons will ultimately build towards the topic of collective bargaining in professional sport. And so, first of all, we're going to identify and discuss a couple of major federal laws that are really important for us to understand if we're going to understand antitrust and labor law. So, this is an area of law that essentially monitors business practices. Now, this is different from constitutional law, which focused on governing state actors. Right now, we're focused on looking at private businesses and how their business practices operate. And we want to make sure that those private businesses and companies stay within the bounds of the law when they're operating. Um, so these are the four major laws we're going to discuss today, and I think you'll note a pattern here after a while that all of this is building toward a collective bargaining system that exists today in the professional sport industry. Okay, we're going to start by discussing the Sherman Antitrust Act of 1890. Now, there are two major sections to this law, and we're going to break down those sections here in a minute, but I'm going to give you a really brief overview of the Sherman Antitrust Act before we do that. Overall, this is an anti-competition law, okay? It prohibits anti-competitive business practices. What does that mean? Basically, this law is designed to promote and regulate competition and make our competitive economic system work. End goal for the Sherman Antitrust Act is for consumers to walk out the winners, right? If there's fair competition in the marketplace, then prices go down, quality is better, the consumer wins, right? That's the sort of the overarching goal of the Sherman Antitrust Act. It was initially created with the idea that it would protect this free market capitalism that we exist in. So that's sort of an overarching definition. Again, there are two major sections of the Sherman Antitrust Act, so I'll walk through those now, and I'm going to bring in some sport-related examples so this doesn't get too dry, because I know it can be. So Section 1, as you can see here, prohibits restraint of trade in interstate commerce. So a couple terms here that we need to identify. So first of all, interstate commerce means essentially any business that crosses state lines, okay? So any business that requires communication, monetary exchange across state lines would be classified as interstate commerce, okay? Now, what are we talking about when we say restraint of trade? Well, basically, any activity that limits business transactions across state lines would prohibit restraint of trade, okay? Now, keep in mind, Section 1 only applies to those businesses that actually participate in interstate commerce. Go to our question here, which is, do sport leagues at the professional level participate in interstate commerce? I would normally ask that to the class, but since we're not live, I'll go ahead and answer it for you. Yes, professional sports leagues do operate across state lines. Therefore, they would be considered operating in interstate commerce. We know that in order to operate, really all of our professional sports leagues require business transactions across state lines, whether that's revenue sharing at the league level to the various teams or simply the games that are played in different cities across the country. So yes, sport leagues do participate in interstate commerce, which means that they do have to follow Section 1 of the Sherman Antitrust Act, which means it's illegal for them to restrain any trade across state lines. Now you might be thinking, what does this mean? Well, I thought it might be helpful to share with you some historic examples of how Section 1 of the Sherman Antitrust Act have been applied in a sport context. So hopefully this will help sort of contextualize this for you. So going back to Curt Flood, who was St. Louis Cardinal back in the 70s, he filed a lawsuit against Major League Baseball under the Sherman Antitrust Act, and he argued that Major League Baseball's reserve clause policy limited business across state lines, right? It made it so that basically players did not have any choice in where they ended up in terms of the teams that were selecting them, and really did not allow for competition across those state lines. Another case under Section 1 of the Sherman Antitrust Act, some of you might remember Maurice Clarett. He was Ohio State football player, very talented, skilled. He basically didn't want to stay in college. He wanted to go straight into the NFL after his first year in college. He argued in court that the NFL's draft policy, which was you had to have 3 years out of high school before being drafted, he argued that that was a restraint on trade, right? That basically by not allowing players to enter into the draft earlier, the league was actually restraining people's ability, the team's abilities to draft talent. Now, he was not successful in that case because basically the court looked at the CBA and said, you know, the CBA is agreed upon by the current players and the teams. So essentially, they had agreed that this was the policy, right? That they were going to have a 3-year policy. And because that was agreed upon in the CBA by the current players and the league, then that stood. And ultimately, I think what the court decided was he wasn't a current player, right? He was seeking to be a player in the league, but he wasn't a current player. So he essentially did not have a say. And then finally, our old pal Ed O'Bannon, we know, former NCAA basketball player. So far in our reading of court justice, we know Ed's filed a case or had filed a case against the NCAA. I think primarily our reading so far is focused on his case against the NCAA and players gaining the right to generate revenue off their image and likeness. We haven't talked much yet about the case against the NCAA's arrangement with EA Sports, which was the video game company that actually produced the video game that Ed saw at his friend's house. And so in Ed's case against the NCAA, he did argue under the Sherman Antitrust Act and essentially argued that the NCAA and EA Sports using the likeness of the current and former players and not paying them limited their ability to generate income across state lines, right? He was successful in this, and we'll find out more about this as we keep reading. And there was a settlement to this aspect of the case as well. So former players did get a little bit of cash for this, not much. But again, these are some examples or premier examples, I would say, of players, former players filing lawsuits under the Sherman Antitrust Act. With that said, I think it's important to note that historically, some of these sports leagues have enjoyed what we would call an antitrust exemption due to the unique structure of pro sports, which makes it quite a different beast than other private organizations, right? Where we have essentially one organization that has several competing teams within it that agree on certain terms in their collective bargaining, but also compete on the field or on the court. So because of that unique structure of pro sports, at times courts have provided exemptions to leagues. So important to note that, I think. Okay, so we've looked at Section 1. Again, we know Section 1 prohibits the restraint of trade across interstate commerce. Section 2 makes it illegal for a private company to monopolize. So what do we mean when we say monopoly? Well, not the board game, although that's a good one. A monopoly in this context is when one supplier has significant market power, and in that they decide to raise prices or force out competing companies. So basically, they dominate by excluding. Microsoft was viewed as a monopoly and actually legally found as a monopoly, I think back in the 90s. That was a pretty major case under Section 2 of the Sherman Antitrust Act. Now, the question I have, which I think is an important one, even though it's difficult to answer, is do sport leagues act as monopolies? Now, this is something that historically has been argued that sports leagues as individual entities, in fact, do operate as a monopoly, since typically there's no competitive leagues, at least not in recent years. Now, when these arguments have been made in a court setting, courts have generally said that these sports leagues operate as natural monopolies, meaning it's not purposeful. Rather that the leagues are operating successfully, and therefore other leagues, competing leagues, are not popping up, right? The NFL or the NBA aren't trying to purposely keep other leagues out. They're just not forming. So in theory, if another league wanted to try to compete, they could create a system in a league and try to do that. Now, only in the case where one of the existing league acted in a way to try to force those companies out or compete in a way that gave them more market power, would there be an issue under Section 2. So generally speaking, courts view sport leagues as a natural monopoly, and therefore it's legal. Now, there has been a recent antitrust lawsuit involving Ticketmaster and StubHub that I thought would be interesting to share with you. And this involves specifically Section 2, or this issue of monopolies. So here's the gist of the case, and I'll share the article with you as well on RegGNet if you want to read more. Basically, StubHub filed a lawsuit against both Ticketmaster and the Warriors. And essentially what they argued was that the Warriors, in their outreach to their season ticket holders, was basically telling them, hey, you only have this one option to resell your tickets, and that's Ticketmaster. That's our partner. And not only told them that in an email, but also made them sign something saying that they would only use Ticketmaster to resell their tickets. So StubHub, seeing this, argued in court that this relationship was creating a monopoly, right? Basically, they felt like their company was forced out of the secondary ticket market because of this relationship that existed. This case goes to court. Essentially, the judge ends up throwing it out. Basically, what she said is that the argument itself was limited because the Warriors were selling their own product, right? They weren't trying to sell some kind of other product in the secondary marketplace. They were selling their own product through this partnership that they had that existed. And she called that, again, a native or natural monopoly that every manufacturer has when they're producing or selling their own product, and therefore can't be found liable under antitrust law. Excuse me. So ultimately, this case was thrown out. Although a lot of people were interested in this topic, because obviously this is kind of a new territory in the sport industry, where we're seeing these relationships between teams and ticket sellers, where they are the single ticket seller, and whether or not this would become an antitrust issue. I think the fact that this case was thrown out is pretty telling in terms of how the court views this. This is another one of those examples where the courts, when they get some of these cases involving the sport industry, just say, hey, figure this out on your own. This is something that should be handled outside of the courtroom. And I think the judge in this case felt that way as well. Okay. So we've covered antitrust law now, and hopefully you feel like you have a pretty good grasp over both Section 1 and Section 2. Again, I'm going to post both of those articles to Regina if you want to read more, just to get a little bit more context. But I do want to move on now to one of our labor laws of discussion, and that's the Clayton Act. So just to give you a little bit of a history lesson, so Clayton Act is passed in 1914. Prior to this law being in place, it was illegal in the United States for employees to unionize or even come to the bargaining table with their employers. So historically, employers had challenged a union's right to organize and actually claimed that it was a violation of antitrust law. Right? Basically, unions got in the way of free competition because it meant employers had to pay more and provide more benefits. So it's kind of an interesting dynamic that employers fought unionization for so long and actually argued that it was in violation of antitrust law. But then comes along the Clayton Act in 1914, and it basically created an exemption from antitrust laws for labor unions specifically. So this is a major win for employees in the United States, right? Now they are provided this avenue for which they can actually unionize, come together as groups of employees and come to the negotiating table with their employees. Not only did this create this antitrust law exemption, it also basically came out and declared that, humans are not commodities. They actually have a say in their working conditions. Really, ultimately, what this law did is really start a labor movement, right? And it legalized a labor movement that had been building for a long time prior to this point, where employees had really been poorly treated across a number of industries in the U.S. And this law, the passage of this law, really legalized that labor movement that had been building. So Clayton Act also stated that unions, once they've come together, they can negotiate with management on a number of issues, things like pay, hours, other key terms that prior to this point they really hadn't had the opportunity to have a say in. So all of this to be said that in addition to legalizing the labor movement, the Clayton Act also creates this concept of collective bargaining, where basically negotiations occur between the employers and the employees with the goal of reaching an agreement to regulate overall working conditions. So Clayton Act is a key labor law in the U.S. because it legalizes the labor movement, it legalizes unions, and it creates the system for which union employees can negotiate with their employers for basically better working conditions. And keep in mind, at the time, 1914, we're not really talking about a very professionalized system for the sport industry. So you'll see that those players' associations come a little bit later. But in the interim, the Clayton Act is really useful for other industries like blacksmiths, railroad workers, steel workers, teachers, other industries that were a little bit more established at the time. And it gave those employees the right to unionize and really do better for themselves in terms of working conditions. Okay, another important law regarding labor in the U.S. is the National Labor Relations Act. So we learned about the Clayton Act. The NLRA actually went one step further than the Clayton Act. It expanded those protections for laborers under private employers. So essentially, it expanded those rights beyond public employers like schools and other workers. So a couple other things here in regards to the National Labor Relations Act. It gave private employees the right to negotiate with their employer over some of those specific terms and conditions we talked about, things like hours, wages, and other concepts like health care and other benefits. It also basically created a procedure or a way for groups of people to unionize, private organizations. And again, that did not exist prior to the passage of this law. Some of you might remember a few years ago, the Northwestern football team, several players from that team came together and tried to form a union. They were unsuccessful in that feat. However, they did go through the process, and in order to apply to become a union, they had to file their paperwork with the National Labor Relations Board. And ultimately, that process wouldn't have been possible without this bill being passed in 1935. Okay, so both the Clayton Act and the National Labor Relations Act provided an outline for the types of subjects that employers have to negotiate over with their employees. We call these mandatory subjects for negotiation. So mandatory subjects are subjects that must be negotiated in order to maintain fair labor practices. So the three overarching categories here are hours, wages, and terms and conditions of employment. Obviously, there are several other sub areas that are included in that, but those are kind of the main headers. Permissive subjects are another category of subjects. Now, these are subjects that management is not obligated to negotiate over, and there cannot be an impasse over. What does that mean? So an impasse is basically when collective bargaining comes to a halt because there's a stalemate in the negotiations. Now, an impasse can occur through the negotiation over mandatory subjects, but it cannot occur over a permissive subject. So think of permissive subject as a sort of bonus issues up for debate during a collective bargaining agreement. These are not mandatory subjects under law. These are kind of extra topics that one or both parties wants to discuss. An impasse cannot occur when discussing permissive subjects, but it can when discussing mandatory subjects. And we'll talk about what some of those impasses might lead to for professional sports teams in a little bit. Okay, one more labor law I want to mention here, and that's the Fair Labor Standards Act. So this is 1938, again, another federal law. Main purpose here is to basically eliminate labor conditions that were deemed detrimental to the maintenance of minimum standards of living necessary for health, efficiency, and general well-being of others. So here what we're looking at is essentially there were standards set up for things like minimum wage, overtime pay. Obviously at the time there were issues with child labor, so this created age restrictions on children working. These are all examples of some of the standards that were set in the Fair Labor Standards Act. And you can see that there are some things that the FLSA does not cover, and that's sort of these extra things like benefits like vacation, sick pay, those types of things. The federal government does not want anything to do with. Employers are able to determine those things on their own. But this law basically recognized that there were some basic standards in terms of employees and treating employees in a way that allows them to, sort of maintain a standard for living in the United States. Ultimately keeps employers from taking advantage of their employees as well. Now, there are some exemptions under the FLSA. And basically what that means is there are certain classifications or employee groups in which the Fair Labor Standards Act does not apply. So what does that mean for sport organizations? Well, if you have employees or a group of employees that falls into one of these categories, you can get around some of the paying of overtime pay. Or creating certain other standards that are listed in the Act. So I want to show you a couple of examples here of what some of those exemptions are. So first and foremost, this amusement or recreation exemption. Basically, the courts have said that some sport or recreation organizations are only seasonal in terms of their operations. So think of like an aquatic center or a golf course. Those places may only be open certain months out of the year, and therefore those employers are provided an exemption under the FLSA, meaning that because their employees might only be working 3 or 4 months out of the year, they do not have to pay them overtime, as opposed to a company that's open all year round and those hours are expected throughout the year. Another exemption common in our field is this trainee or intern exemption. Basically, this law says that if someone is getting some kind of educational experience through the company, so they're being hired as an intern or they're training for another job, that those groups of employees are also exempt from things like the FLSA standards. Obviously, this one's pretty common in our field, and we're very reliant on unpaid labor, like interns in the sport industry. So knowing that some of these policies don't apply to that group, I think is important, whether or not we think it's right or wrong. Finally, this one I think is the most interesting to me and one that's involved the most change in recent years, and that's this executive or administrative exemption. This is also known as a white-collar exemption. And basically, the group of employees that this one applies to are full-time employees that are salaried employees that make a certain minimum salary. And if they make this salary that's above a set threshold by the federal government, then they do not get paid overtime. They don't have to succumb to these other standards in the Fair Labor Standards and Act. And the rationale behind this historically has been, hey, if someone's a salaried white-collar employee, they already enjoy a professional position, they have a set salary that's already above minimum wage, therefore they should not benefit from working beyond a 40-hour work week. They can still work beyond a 40-hour work week, but they're not going to get paid the overtime for that. Now, if you think about the sport industry in particular, we ask a lot of people to work beyond a 40-hour work week, right? So this is a particular exemption that becomes interesting for us, especially when there have been some proposed changes to the threshold in recent years. So I'm going to talk to you about that on the next slide. Okay, so essentially, here's the history of the executive or administrative exemption threshold. The previous threshold for many decades was $23,000. So if you were an employee, let's say you're employed by a college athletic department, as long as you made at least $23,001, so as long as you made more than that threshold, you were exempt from the Fair Labor Standards Act. So basically, your college athletic department would not have to pay you overtime as long as you met that threshold. Now, this threshold was in existence for many years without any changes. In 2014, the Obama administration proposed an update, basically saying, we haven't adjusted this number for inflation over time. It's time to do that. So they proposed bumping it up to $47,000, which, as you can see, is quite a big jump. Although if you adjusted for inflation over that time, you actually would have been looking at closer to $50,000. So it was still very much in reason to adjust for inflation. But as you can imagine, the response to this from businesses across the country was one of concern. Basically, if this change went into effect, they were either going to have to bump up base pay for a number of their employees, or they were going to have to start paying them overtime. And I bet you can imagine in the sport industry, there's a lot of employees that make between that $23,000 and $47,000, right? That were working well beyond 40-hour weeks. So there were a lot of folks in the sport industry that were very concerned when this was proposed in 2014 and how this might change the financials of the sport industry, particularly in college athletics. Now, what occurred is a lot of businesses were worried and upset about this, and a lot of Republican states came together and filed a lawsuit against President Obama and the administration and basically claimed that this was an unfair jump and that businesses couldn't adapt in this time, that it needed to be a more gradual increase. The courts actually agreed with those states, and essentially that decision, which was going to go in effect in 2016, never went into effect. Now, fast forward a little bit, Trump is elected. The Department of Labor still wants to make some adjustments, right? They're not just going to ignore these proposals. So they kind of come to some middle ground between the previous threshold and the proposed threshold in 2014. And they settle on and approve a new threshold of 35,568. So that's the current threshold as of January of this year. So now the exemption only applies to employees that make above that amount. You can see that this still is probably going to impact a number of sport organizations in terms of their employees that are above that $35,000 range. But it's also not nearly as widespread as if the threshold would have gone up to 47,000. So this is an interesting one in terms of change, and I always spend time on this because I want entry-level sport industry employees like yourself to be aware of this, and that if you're getting an offer for a job and it's just above this threshold, there's probably a reason for that, right? The employee or the employer is trying to avoid having to pay you overtime beyond those 40 hours, and they're quite aware of what these thresholds are. One more thing I will note about this bill that is interesting is that there are some caveats. So the salary level or threshold does not apply to teachers and outside sales employees. So again, more exemptions here. Basically, the Department of Labor has said that anyone in an outside sales position that's probably working on a commission-based structure, this does not apply. I can tell you from working in sales, there are a lot of those entry-level outbound sales reps that are probably making just above this old threshold number even, that are working on a commission-based structure, and those positions would not apply to this, even though those employees are putting in a lot of hours. So that's something, again, that's there to protect the business from having to pay out too much money. Another interesting caveat is that the threshold does not apply to teachers. And when this initial proposal came out in 2014, a number of colleges were kind of reworking the job descriptions of their coaching staff to make sure that those coaches could be deemed as doing a lot of teaching in their roles as coaches. Because if they were able to prove that the majority of what the coach did was instruct or teach their student athletes, then they could be classified as teachers and not have to comply with this. So just some interesting tidbits here in terms of the FSLA, which I think are pretty interesting and certainly impact you as entry-level employees, and likely will impact you when you're in a hiring position down the road. I am going to upload an interesting article from prior to this latest threshold being put in place. But this was sort of the reaction from college athletics at the time in terms of how they might react or adjust to these new rules. Okay, I'm going to pause here and then start up the second video for you on collective bargaining.